class is not set up for my normal routine. Okay, now we're almost in business. Okay. All right. Hi, everyone. 1, 2, 3, 4, 5, 6, 7 out of 44. I am glad you're all here. If I was a jerk, I would step 2 feet off camera and hold it, pushing for the final exam. But I will spare that because you can't all keep it a secret. I considered that once. I held a review session or something. I said I will give you something, private, but everyone's going to leak it anyway. So it doesn't matter. So I appreciate the 7 of you who are here. Hopefully I'll see more of you on Sunday. If I won't, then your loss. If you are watching from home, please email me and tell me that, welcome, we now have 8. Please email me and tell me if you're here, mark yourself present, but I want to email if you're not in this room. Any questions from last class? Any questions on the executive power and ex parte merriment? A few in the crowd, right? Any questions on ex parte merriment? Any questions on Youngstown? Anything in your minds? Okay. So our discussion today is on a couple cases you've probably heard of, and a couple other cases you probably have never heard of, and a fairly recent case as well. And because we're such a small class, I don't even need to do the poll today, so I can just call on you all to see what you think. But there's a phrase in Justice Breyer's dissent in the Ziglar v. Abbasi case that is worth focusing on for a minute. And it's translated different ways, but it's basically this. In the times of war, the laws fall silent. And this was first said by Cicero more than 2,000 years ago. So this is not anything new. But what does this mean, China? This idea that during the times of war, the laws fall silent.
I think it means that you have to take extraordinary measures during times of war. You can't always expect to follow the law as it is stated. You have to kind of mold it to how you need to run the country. Okay,
so the obvious question is, who gets to decide when that conflict is over so that you can return to the normal standard?
I'd want to say Congress, maybe.
Well, is it Congress or is it the courts? All right. So, what do you think? I mean, how does this work? This idea that when during times of war the laws fall silent, right? How are we supposed to know? Obviously, when the laws speak up again, and how does that work?
Logically, I would think it's Congress as well, just because they have the authority to declare war. Wouldn't they have
well,
the
they declare war, but who decides when the war is over? Ew. Yeah. And Rachel, what happens when it's a war that's not declared? How do we handle this when the executive says there's an emergency? We need to deal with this now.
Then they exert their executive power in doing that?
Well, I'm asking the courts, right? How are the courts?
I'm still confused. What do you mean? How do the courts?
How are the courts supposed to know when an undeclared war is over? To go back to the normal regime.
Well, in going with Breyer and Ginsburg and their dissent in Ziglar, they said that even in wartime or peacetime, like the judicial branch would still stand ready, and they should have at that time, I don't know, sufficient time to reflect.
Reflect.
Calmly.
Calmly, and then what does that mean? Reflect calmly.
So, like, the emergency argument might work during times where everybody's all worked up, like, when there's, like, an immediate threat. But after the immediate threat is over, I guess courts have some time to exercise said judicial virtues in a calm reflection.
Oh, okay. So I think the 3 or 4 of you have called on have hit on an important point, right? In the abstract, everyone's okay with perhaps the laws falling silent in a time of war. But when you actually start thinking about it, it's the details get fuzzy, right? The actual way of applying that isn't so clear. First, how do you know when to turn the laws back on? Second, how do you know when the war is beginning, when the war is over? And third, what does it mean the laws fall silent? They're still in the books. No one repealed them. There's not been an amendment to the Constitution. Is the Constitution like a light switch? You can flick it on and flick it off. So the reason why this quote's important is that a couple of years ago, a reporter asked Justice Breyer, could Korematsu happen again? Happen again. Breyer responded, they put 75,000 Americans in camps. I doubt it. This country has developed a strong tradition of civil liberty. So Breyer is basically saying this can never happen again. Justice Scalia was asked, this is before he passed away, of course, duh, we don't have zombie Scalia, but Justice Scalia was asked the same question. He said, quote, well, of course Korematsu was wrong, and you're kidding yourself, though, if you think the same thing will not happen again. And he repeated this maxim, in times of war, the laws fall silent. He added, that's what was going on, the panic about the war and the invasion of the Pacific. That's what happens. It was wrong, but I would not be surprised to see it again in time of war. It's reality. So this point, right, of how the courts are supposed to do their jobs when people are dying and fighting abroad is one of the most difficult tasks of a judge. We studied one case last class, Youngstown. This stands alone as one of the only cases ever where in a time of war the justices told the government, no, you can't do this. And the government complied, and indeed the war went on, and they got their steel from somewhere else. But more often than not, during these times of conflict, the court doesn't tell the government no. Maybe they'll find that there's no standing. Maybe they'll find the case isn't properly before the justices. Maybe the justices will simply say, we lack the information to second guess the military, we'll defer. Right? There are lots of ways for this to happen. But generally the government wins. And in a couple of the cases we'll study today, the government won. And even where it didn't win, it got what it wanted. Okay? So before we start, I want to show you some videos. We'll do Dames and Moore later. I want to do the Japanese detention cases first. I want to show you this video. And if you watch it, you would think it's like a piece of government propaganda. But it's not. This is real. This was an actual film, newsreel, right? Before you had TV at home, you would go to the movie theater, you'd watch a newsreel. This is an actual newsreel put out by the U.S. government in the 1940s. It's from 1940, I don't know the year, but 1940s at some point, okay? Just watch, about 9 minutes, but it's worth watching it.
Japanese attacked Pearl Harbor, our west coast became a potential combat zone. Living in that zone were more than 100,000 persons of Japanese ancestry, 2/3 of them American citizens, 1/3 aliens. We knew that some among them were potentially dangerous, but no one knew what would happen among this concentrated population if Japanese forces should try to invade our shores. Military authorities therefore determined that all of them, citizens and aliens alike, would have to move. This picture tells how the mass migration was accomplished. Neither the Army nor the War Relocation Authority relished the idea of taking men, women, and children from their homes, their shops, and their farms. So the military and civilian agencies alike determined to do the job as a democracy should, with real consideration for the people involved. First attention was given to the problems of sabotage and espionage. Now, here at San Francisco, for example, convoys were being made up within sight of possible Axis agents. There were more Japanese in Los Angeles than in any other area. In nearby San Pedro, houses and hotels occupied almost exclusively by Japanese were within a stone's throw of a naval air base, shipyards, oil wells. Japanese fishermen had every opportunity to watch the movement of our ships. Japanese farmers were living close to vital aircraft plants. So as a first step, all Japanese were required to move from critical areas such as these. But of course, this limited evacuation was a solution to only part of the problem. The larger problem, the uncertainty of what would happen among these people in case of a Japanese invasion, still remained. That is why the commanding general of the Western Defense Command determined that all Japanese within the coastal area should move inland. Immediately, the Army began mapping evacuation areas and for a time encouraged the Japanese to leave voluntarily. The trouble for the voluntary evacuees soon threatened in their new locations. So the program was quickly put on a planned and protected basis. Thereafter, the American citizen Japanese and Japanese aliens made plans in accordance with orders. Notices were posted. All persons of Japanese descent were required to register. They gathered in their own churches and schools, and the Japanese themselves cheerfully handled the enormous paperwork involved in the migration. Civilian physicians made preliminary medical examinations. Government agencies helped in 100 ways. They helped the evacuees find tenants for their farms. They helped businessmen lease, sell, or store their property. Now, this aid was financed by the government. The quick disposal of property often involved financial sacrifice for the evacuees. Now the actual migration got underway. The Army provided fleets of vans to transport household belongings, and buses to move the people to assembly centers. The evacuees cooperated wholeheartedly. The many loyal among them felt that this was a sacrifice they could make in behalf of America's war effort. In small towns as well as large, up and down the coast, the moving continued. Behind them, they left shops and homes they had occupied for many years. Their fishing fleets were impounded and left under guard. Now they were taken to racetracks and fairgrounds where the Army almost overnight had built assembly centers. They lived here until new pioneer communities could be completed on federally owned lands in the interior. Santa Anita Racetrack, for example, suddenly became a community of about 17,000 persons. The Army provided housing, plenty of healthful, nourishing food for all. The residents of the new community set about developing a way of life as nearly normal as possible. They held church services, Protestant, Catholic, and Buddhist. They issued their own newspaper, organized nursery schools, and some made camouflage nets for the United States Army. Meanwhile, in Arizona, Utah, Colorado, Wyoming, and elsewhere, quarters were being built where they would have an opportunity to work and more space in which to live. When word came that these new homes were ready, the final movement began. At each relocation center, evacuees were met by an advanced contingent of Japanese who had arrived some days earlier and who now acted as guides. Naturally, the newcomers looked about with some curiosity. They were in a new area, on land that was raw, untamed, but full of opportunity. Here they would build schools, educate their children, reclaim the desert.
Reclaim the desert.
Their own physicians took precautions to guard against epidemics. They opened advanced Americanization classes for college students, who in turn would instruct other groups. They made a rough beginning at self-government, for while the Army would guard the outer limits of each area, community life and security within were largely up to the Japanese themselves. They immediately saw the need for developing civic leaders. At weekly community meetings, citations were given to the block leaders who had worked most diligently. Special emphasis was put on the health and care of these American children of Japanese descent. Their parents, most of whom are American citizens, and their grandparents, who are aliens, immediately wanted to go to work. At Manzanar, they built a lab house and began rooting guayuli cuttings. The plants, when mature, will add to our rubber supply. At Parker, they undertook the irrigation of fertile desert lands. Meanwhile, in areas away from the coast and under appropriate safeguards, many were permitted to enter private employment, particularly to work in sugar beet fields where labor was badly needed. Now, this brief picture is actually the prologue to a story that is yet to be told. The full story will begin to unfold when the raw lands of the desert turn green, when all adult hands are at productive work on public lands or in private employment. It will be fully told only when circumstances permit the loyal American citizens once again to enjoy the freedom we in this country cherish, and when the disloyal, we hope, have left this country for good. In the meantime, we are setting a standard for the rest of the world in the treatment of people who may have loyalties to an enemy nation. We are protecting ourselves without violating the principles of Christian decency. We won't change this fundamental decency no matter what our enemies do. But of course, we hope most earnestly that our example will influence the Axis powers in their treatment of Americans who fall into their hands.
Huh. Something, huh? Yeah, I play that every semester. It's a long video, but it basically summarizes the entire class in a single video, doesn't it? So the story here, right, involving, this is Fred Korematsu. This is a younger life. This is him later in his life. He died in the 1990s, the last 15 or 20 years. This is Gordon Hirabayashi. Endo somewhere down lower. And that's Matsuye Endo, who was the other litigant in this case. It's difficult to explain this issue today, because you watch it's like, oh my God, you know, they're locking these people up in camps and saying, oh, they're working, yeah, they're taking care of their kids. But this was something that was implemented by the U.S. government in swift response to the invasion on Pearl Harbor. And the part that I think is most difficult for students to grasp is the extent to which there were a distrust of Asian people, and Japanese in particular. We're familiar with the idea of racism with Hispanics and African Americans, but the idea of the anti-Asian animus doesn't pervade today the same way it did decades ago. And we read the case of Yick v. Hopkins. We will read it later in the semester, and you'll see how this animus was there. So this was the actual announcement that the U.S. government posted. You saw a copy of it in the video. And it says, Western Defense Command and 4th Army Wartime Civil Control Administration, San Francisco, California, May 1942, so basically 6 months after Pearl Harbor. Instructions to all persons of Japanese living in the following areas, and it listed the various areas. You are required to report to this station, it's hard to see, by Sunday. Right? So basically in the span of a couple days, you are required to show up to this facility. Now, what was going to happen to you here? You were going to have to sell your home at a loss. You were going to have to sell your business at a loss. Whatever they gave you, that's what you took. You had to bring all of your possessions, and you could put on a bus or a train to some sort of camp. Now, initially, the government didn't have any infrastructure for this. They put them in was effectively a campground or a racetrack, right? With this huge open field, and they were tents. And over time, they built a number of, here's a map. They call them assembly centers. That's where people had to report to. And there were the relocation centers. That's where they were relocated to. And then the isolation centers. That's where the more serious cases were held. And you can imagine, I could just look at your faces, all of your faces look very sad and very upset, which is entirely reasonable. This was the headline of the San Francisco Examiner. If you can't read it, it says, ouster of all Japs in California near! Exclamation point! Not like, oh my God, they're ousting the Japanese. It's coming, right? It's happening. Right? That's the headline, the front page of the newspaper. There was a legitimate fear that Japanese Americans had loyalty to the Emperor of Japan. And this wasn't just for people who were aliens. If you watch the video, they focus on the kids when the little kids spilling the cup of milk. These were U.S. citizens, people born in the United States, who were citizens just the same as anyone else. And their parents were probably citizens. In fact, I think half, maybe even more than half of the people in these various camps were U.S. citizens. Right? These aren't people who were here illegally. They were legitimate citizens. And I show this cartoon. You should recognize the style of art. It's Dr. Seuss, or you may know him as Theodore Gazelle. And this is a cartoon that Dr. Seuss drew, which refers to the fifth column, which refers to these, the risk that the Japanese would sabotage the United States. And you see in the roof it says, waiting for the signal from home, that is Washington, Oregon, California, and a line going all the way out with Japanese people receiving blocks of TNT, explosives. And I explained that, didn't I? And you don't believe me? Look, Dr. Seuss, right there. Cat in the Hat, right? Green eggs and ham. Fifth column. So there was an all-out effort within the government to, I'll use the word propaganda, I don't know the other word to use, to create propaganda concerning the risk that Japanese Americans would blow up boatyards and blow up shipyards, right? And you saw the video of these people, the fishermen sitting near the docks, they know where the troop movements are. So the idea was we had to exclude them, put them in camps. So this is one of the temporary camps. They basically had no floors. They were just dirt floors. This here, I got a picture, is a Topaz internment camp in Utah, where if you've been to Utah, sitting in the summer in the desert there is not an enjoyable experience. Here's a photograph of they're locked in a camp now. Yeah, Yeah, I actually had an argument with Randy, my co-author. I wanted to call them concentration camps. He said detention. I'll call them concentration camps in class. But I mean, the phrase concentration camp means literally you're concentrating people in a camp. So it's a little bit more, but I'll move here. Here's a photograph of some of the people interned at these camps. Make it a little bigger. Here they are being rounded up. I mean, they were put in a bus and driven out to the middle of the desert. Who the hell knows where? And you know, their hats on, their suits, and that's what they had. I like showing this picture too because people don't quite appreciate it, but there was a legitimate effort to create propaganda to suggest that this was normal. And Eleanor Roosevelt, the wife of President Franklin Roosevelt, visited a number of these camps. And it was basically a PR trip, right? That's the only way I can describe it. And here you are, see all these, you know, women, their hair is well kept, and they're smiling, they're all happy. I mean, can you imagine this photo? It's like, all right, everyone, smile, right? Smile. First lady's here. President just locked you guys up. This is a picture years later with Fred Korematsu and Hirabayashi and another person, Minoru Yasui, some years later. This is Korematsu and Rosa Parks. Eventually, Korematsu received a check, a reparations check for his internment. See a little U.S. Treasury check at the bottom he's holding up there, and a letter. And he received the Nobel, I'm sorry, not the Nobel, the U.S. Presidential Medal of Freedom in '98, and he died, 2005, so about 15 years ago, 20 years ago now. But the reason why I show these pictures, especially this headline of the paper and the Dr. Seuss book, is to illustrate how widely accepted this was. So what happened? Pearl Harbor happened. Congress declared war. What is the effect of Congress's declaration of war? It gives the president additional powers that he lacked before. And what are the scope of those powers? Not entirely clear. But after the declaration of war, President Roosevelt issued an executive order. And the purpose of the executive order was to deal with not only the threats abroad, but to deal with the threats perceived in the homeland. And Roosevelt delegated to this guy, General DeWitt, who was the commander of the Western Defense Front, the power to deal with this local threat. And the Western Command dealt with this with a couple different plans, right? A couple different plans. One of which, and this was one of the first ones that was tested in courts, was a curfew, right? I mean, did any of you actually think when we had Hurricane Harvey a couple weeks ago, did the mayor have the power to put in a curfew? Did anyone think about that? Who is Mayor Turner to tell me I can't leave my house if I want to? I've done nothing wrong. I've committed no crime. You have no cause to stop me. I have the freedom to travel. I was thinking about that. I'm pretty sure I tweeted something about it also, but the entire notion of a curfew is a very strange idea that you can basically detain someone and arrest them without any cause. Now, the reason why you have a curfew is not because you want people to stay in their homes. It's so that you can arrest them the second they step outside without cause, right? You're basically arresting them for violating the curfew. Now, why did Mayor Turner do it? To stop looting, right? He said, we don't want people looting, so that way if they see you on the street, they can just arrest you and not have to wait for you to break a window, right? That's why they have it. But the first approach that the Western Front, the Western Defense Command, used was curfews. That said, if you were of Japanese ancestry, you couldn't leave your home after a certain hour. You had to be home at night. That was tested in the first case, Hirabayashi. The second policy used by the government is what's called exclusion, right? That's this, right? Requiring that certain Japanese Americans, and there's people of Japanese descent, even U.S. citizens, who lived in certain zones near the coast, and by the way, it was like, I'll show you this map again, right? It's basically the entire western coast, all the way from Washington all the way down to California. See all these cities? I mean, like, even if you were like inland, like in Stockton, right? Pomona, you're pretty far from the water. you were excluded. The exclusion order was challenged in Korematsu, the second case, and that's when the court upheld. The third policy, which what people usually think of when they think of Korematsu, was detention, right? You have to separate these two issues. Korematsu considered the exclusion of the Japanese people from their homes on the coast. Endo, ex parte Endo, considered whether they can be detained once they get to these homes. So again, did the power to kick people out of their homes in the West Coast? And if so, could they keep them at these camps in the wilderness? So you have Hirabayashi with the curfew, Korematsu was about exclusion, and Endo was about detention. And to give you a preview, the court upheld the curfew of Hirabayashi, the court upheld the exclusion in Korematsu, but the court struck down the detention not on constitutional grounds, on some weird statutory grounds we'll get to a little bit later. All right, everyone get the general frame, right? These are the three policies. People don't even study Hirabayashi. Most case books don't include it, or they definitely don't include Endo. But you need to read all three to understand the sequence, right? Korematsu was only about exclusion. It was not the entire policy. Everyone okay with that? All right, David, you want to give me the facts on Hirabayashi, please?
When Hirabayashi, you had a gentleman who was out. I mean, basically, there was a curfew issue, and he knew that there was a curfew.
Oh, he knew, yeah.
He knew there was a curfew, but he was out anyway.
Yeah.
And
did he break it on purpose?
Pretty much.
Yeah, that's bravery. I mean, it's you know, people say, "Oh, I put a message on Facebook. I'm so brave." No, I'm sorry. This guy's actually brave, right? Let me put this picture up for a minute. He knew. Where is he? Here he is. Right? He knew that if he went out at a certain hour, because he was of Japanese ancestry, he was going to get arrested between 8 p.m. and 6 a.m. Right? And he was arrested for violating the curfew. He was also charged with not reporting under the exclusion order, but that was not the basis of the court's decision. The court was actually very deliberate in not reaching that issue, if you noticed. They wanted to only focus on the curfew. So like, we were like, crap, we'll deal with that stuff later, right? So this was, what, 1943. Korematsu was not decided till 44, the following year, right? So David, what did the court do then with Hirabayashi's conviction?
They upheld it.
They upheld it. What grounds?
I mean, essentially because, I mean, they determined that the curfew was the law and that he did break the law.
Well,
I mean,
who made the law here? Which branch of government? Let me ask you that question like that.
It was, they traced it through, it was actually the military.
Good.
That made it, but then they traced it from the military to the war authority.
Yeah.
And then they traced that to the president.
So here I want to go back to Youngstown, right? And you remember Justice Jackson explained that in these separation of powers cases, it's often difficult to know who has what power. So you ask yourself, what powers does the president have and what powers does Congress have? Here, Congress declared war. Based on the powers in that war declaration, the president signed this executive order, 1966. And the executive order says that the prosecution of the war requires protection against sabotage. And President Roosevelt authorized military commanders to take such action they deem necessary. So basically, here's the progression. Congress declared war, gave power to the president. The president delegated that power down to the military commander of the Western Front, DeWitt. And based on that, DeWitt issued the curfew. DeWitt issued the exclusion order, right? So it wasn't Roosevelt. Roosevelt never got his hands dirty. It's one of the things people don't quite realize. He was fine signing this generic order that didn't really say anything, and he let his generals on the ground make these policies up. So really, Hirabayashi was not violating an act of Congress. He was not even violating an executive order of the president. Hirabayashi was violating an order from the general who was acting pursuant to that authority. Okay? right? But then Congress passed a statute, right? Who said whoever shall leave, commit an act, whatever, that's prohibited by the Secretary of War, is in violation of the felony. So what Congress said was, we're going to pass a general statute that says anything that the generals say is bad is now a crime, right? Right? Congress didn't pass a specific statute saying if you're in this area and you break your curfew, whatever. They said, under the authority of the executive order of the Secretary of War, if there's some restrictions they deem applicable to those zones, and you should have known about these restrictions, you're guilty of a crime. Okay? So this curfew has its roots. I think you used the word roots, Dave. Dave, I like that. It has its roots in Congress, but it's really a delegation of authority to generals. And the generals got to decide the content of these crimes. Okay? Based on all these regulations, the curfew was put into effect from 8 p.m. to 6 a.m. Hirabayashi violated it. He knew he violated it. There was no doubt he did it quite deliberately. So the question is, was this conviction lawful? And the court's decision was, I would use the word deferential, right? It basically says, Congress supports this war, the President supports this war, he's acting on the advice of his generals. It's not for us as judges to second guess. Court says it's information within the knowledge of the military. Prudent men charged with the responsibility of our national defense had ample ground for concluding that they must face the danger of invasion and take measures against it. That cannot be doubted. So the court is basically saying here is, we don't know what they know, and what they know may be important.
Well, they even say it's not for any court to sit and review the wisdom.
They say it right there. Pretty direct, right? That in the times of war, we're not going to get involved. That Pearl Harbor was a surprise attack, and the government may have reason to explain why we should not have another one of these. And there was a substantial basis for acting, a reasonable ground for acting. They referenced the threat, they referenced the fifth column. This was in the Dr. Seuss cartoon, right? They referenced the fifth column, right? And they even go further than that, and they say there's evidence that over the last century with Japanese people, they've intensified their solidarity and prevented their assimilation into the white population, right? It's right there, right? It's right there in the U.S. report. Large number of Japanese parents send their kids to schools, right? These schools are sources of Japanese nationalist propaganda, cultivating allegiance to Japan. Children born to dual citizens are considered Japanese citizens. There has been relatively little social intercourse between them and the white population. None of this is necessary for the opinion at all. But I think the justices are actually trying to say, look, we agree with the government that these people are a threat.
Well, I also found it interesting that they quoted McCullough, saying that this is the Constitution that we're expounding.
Not how you usually say excited, is it?
No, and I mean the whole idea of that it's supposed to adapt over various crises, and
Yeah.
so using McCullough to justify this
Well,
extreme.
look though, but look at Marshall, right? This is why I don't particularly like McCullough. I think it's wrong. For exactly this reason. If McCullough teaches a lesson that the Constitution is flexible and judges should adapt it to whatever the circumstances are today, this is what you get, right? If you take Marshall seriously, that the Constitution is a flexible document, this is what you get, right? It often leads to results that perhaps people like, but sometimes that flexibility leads to a result that you don't like. Now, the question though is, was this a violation of the Constitution? So, Ashley, if I just told you before you became a law student, right, can the government put people of Japanese descent in a specific category and throw them in curfew orders, right? What would you probably have told me, just by talking before law school?
I would think that it was not, like,
What provision of the Constitution, even if you knew or not, but now that you know, what provision do you think this would probably run afoul of? What guarantees the Constitution protect?
Like equal.
Yeah.
equality.
Equal protection clause, right? We've mentioned that a few times, right? If equal protection clause means anything, it's that the government can't lock you up in a jail because of your ancestry. Is that maybe probably a fair guess? But take your constitutions, please. Right? Go to page, go to the 14th Amendment.
I think.
Share.
Okay.
Sharing is caring, right? 72. I'm sorry, 73. Right? Equal protection clause, it says, no state shall deny to any person within its jurisdiction the equal protection of the laws. Does the 14th Amendment's equal protection clause apply to the federal government, actually? What does it say? Does the 14th Amendment's equal protection clause apply to the federal government?
No, I guess not, based on the state.
No. So this is one of the rubs. The Fifth Amendment, which you'll find on page 66, is the clause that applies to the federal government. There is no equal protection clause there. Does that mean the federal government can classify people based on their race? At least here they seem to say the answer is yes. Justice Murphy in Korematsu makes it up. He says, oh no, they can't. But you read it.
But what of the line where deprived of life, liberty?
Oh, that was my next question, David. You can take it. What does it mean to deprive someone of their life, liberty, or property without due process of law? What does that mean, David?
I mean, that, without actually putting the person on trial.
Trial. Were any of these people given any sort of hearing before they were put on a bus and sent out to the desert?
When their property was sold for whatever they give it to them for.
So this is why I think the McCullough line is even more dangerous. This case, of course, was wrong when it was decided, right? These were citizens of the United States who were deprived of their life. Well, they actually weren't killed, but they were definitely deprived of their liberty and their property. Maybe some of them did die, I don't know. I could probably look it up, without any sort of hearing. Now, I often ask this to my students, if, let's say, name tag? Yeah. Elizabeth, thank you, I'm sorry. I don't know the name, especially out of seats. Elizabeth, there you go, I didn't see it, I'm sorry. Elizabeth, let's say there actually was a threat of espionage. There wasn't. Let's pretend there was for now, right? How could the government have addressed this short of rounding up everyone on a bus and sending them out to the desert? What could they have done short of this? And ask them what?
Questions.
Like what?
Follow credible leads and see, like, I mean, I don't know.
What would the government be trying to determine with these questions? What would they be trying to figure out? Yeah, loyal. How about issue a loyalty oath, right? Say, will you take a loyalty oath to the United States government?
Well, what if, I mean, like, not that I'm a spy, but, like, if I was one, I would definitely say that.
Oh, you nailed my next question. I wish I could have a class with 10 people. Wouldn't that be awesome? Like a class with 10 people? Ugh, I wish, in my dreams, right? And you're 90. Your class is small, but 40. It's actually a little bit easier. But yeah, you're Elizabeth the spy, right? Or Harriet the spy. You're exactly right. Right? It's easy enough for this schmuck to sit up here and say, of course, just issue a loyalty oath and be done with it. But that's what a spy wants you to say, right? Of course I'm loyal. They're a good spy. They're Jason Bourne, right? They're trained to lie. So, Elizabeth, I'll ask you this question again. Is there, if they actually had evidence that there was a threat of Japanese people causing sabotage, what could they have done consistent with the due process clause to address that threat?
I mean, you just can't group people all into one. You need to talk to people that you actually think.
But we're talking about tens of thousands of people, and the threat is like immediate. They put this order out and said report in 2 days. They couldn't have interviewed 75,000 people overnight. They couldn't do that. Wasn't this a reasonable way of handling it in a quick fashion?
No, it says in here that they had like similar things for like Italians and Germans, and they did do those interviews. in that time.
Oh, so maybe this wasn't based solely on a concern of Japanese. It was based on maybe something else.
Yeah.
Like
so
what?
like a different standard.
Why they give the Japanese a different standard? Yeah?
I don't know. seems like racism.
Seems like racism. Or Justice Murphy, I think one of the more famous quotes in Justice Murphy's decision is that we've fallen into the ugly abyss of racism. Remember that line? In Murphy's dissenting opinion in Korematsu. Okay? Yeah, sir, Kevin.
How close does this tie with the travel ban that we're facing?
Oh, what a good question. That was like 3 minutes down the road, right? So yeah, I'll go to it now. That's fine. Actually, prospectively, one of the reasons I canceled class in October, because at 18th I'm going to DC for the arguments in the travel ban case. So I'll report back the next day on what I hear. I think there's a couple of differences with the travel ban. One, we're talking to people outside the United States, not inside. People inside the United States have lots of rights that people outside do not. A second major distinction is when we're making immigration decisions, we often discriminate based on nationality, right? So if you're going to London, for example, you don't need a visa to go there. You can just hop on a plane and get there. If you want to go to, I don't know, Saudi Arabia, you need a visa. And likewise, people come to the United States. If they want to come from London to the U.S., they don't need a visa. Coming from Saudi Arabia to the U.S., you're going to need a visa. That's because we've decided some countries have relationships that they can travel freely, and some can't. Right? The mere fact that the travel ban listed certain countries with different treatment, and this is Josh talking, is consistent with our broad immigration law. But the argument is that the policy was actually motivated by an animus. This is, I think, Elizabeth said a minute ago, or actually racism, right? That's the reason why people of these 6 nations were selected is because of a hatred of Islam. And they cite the president's statements, the campaign trail, and the South Side. I don't want to go too far into that, but the point where there is the overlap is the government asserts national security is the reason why they need the travel ban. Is that the real reason? Or is that a cover story, right? Is that a pretext, right? Saying, oh, of course, national security, we're doing this because we hate brown people, or whatever it is, right? That isn't the precise issue the court has to address in the travel ban cases, but it's in the same ballpark, precisely because courts are willing to second-guess the stated reason. Here, in Hirabayashi, the government says, well, yeah, the government's right, national security, there's this 5th column, Japanese people go to their own schools, they don't assimilate, therefore it's justified. Right?
What was the accuracy of that? I mean, was that even true?
No, and it wasn't. And I put, wasn't true at all, in fact.
My grandma lived in L.A.
I'm sorry?
My grandma lived in L.A.
Oh, really? In this time?
6, yeah.
Does she remember this?
Yeah, I actually texted her when we were watching the...
Your grandma texts, that's very cute.
Yeah, she's pretty cool. So she texted me and she was telling all that, but yeah, like, I don't remember her ever talk. I mean, I don't ever remember hearing about this growing up. Like,
So the short answer is that the Solicitor General Office had a report which suggested this threat was non-existent, and they concealed it from the court. And in 2011, the acting Solicitor General, a lawyer named Neil Katyal, submitted a letter to the Supreme Court apologizing and saying that his office, the Solicitor General, is the government's lawyer to the Supreme Court. That's what he does. Failed to disclose this, and they concealed this report, saying that the threat wasn't really a problem. And in fact, Katyal is currently now the lead attorney arguing the travel ban case, so he has a very strong a connection to this issue. Yeah, Elizabeth.
Just a comment. Actually, so I'm from Oregon,
Uh-huh.
and when I was in 6th grade, I remember hearing about this because my 6th grade math teacher, science teacher, I don't know, her parents were interned in this campus.
No way, really.
Yeah, which is crazy. Yeah.
It's one of these things where the generation will fade, right? So for people to have been there now, they're probably in their 70s or 80s at this point, right? To have actually, the camp shut down in 44, so probably what, 70-something years ago. You got to be in your 70s or 80s to even have any living recollection. And it's an aspect of human life where memories simply fade, and it's not something that you know it was there. It's history, and I feel that way about 9/11 because, like, I was a senior in high school in 9/11 in New York, but I know the incoming 1Ls this year, and maybe some of you were probably a couple years old in 9/11, 5, 6 years old, And I know in 5 years people will be not alive. And it's no way knocking you. You were born when you were born. God bless you. But it's a difference between having lived a history and reading about it in the books. Like, I'll never forget when I was in college, I was talking about something like President Kennedy. The professor said, "You weren't alive when Kennedy was here. You can't talk about it." And I was like, "What are you talking about?" You know. So things go. So let me bring back to Hirabayashi, the first case. The government cites McCulloch v. Maryland and says this is a constitution intended to endure for ages. And we take this very rigid, formalist structure approach. The courts will not step in. And indeed, I think they went a little bit further and provided additional justifications by citing the fact that Japanese people can't assimilate, that they're a separate nation, that they're a separate race. And at bottom, the court says there's a rational basis to justify this, and it's upheld. Yes, please, Rachel.
So, by the court choosing not to step in and comment, basically saying like, this is an congressional issue, isn't it like a gross miscarriage of justice to choose not to balance the powers? I mean,
well, let me ask the flip side, Rachel. Let's say the opposite happened, and let's say they reversed Hirabayashi's conviction. Mm-hmm. And let's say Hirabayashi then went and blew up a boat in the harbor. What then? I'm asking, I'm being provocative deliberately, right? Hirabayashi was a good guy, but let's just say, hypothetical, devil's advocate. Supreme Court reverses his conviction, Hirabayashi gets out of jail, he goes and blows up a ship in the harbor. Mm-hmm. How does that sit in the judge's conscience? Hindsight's 20/20, it's beautiful, right? But when you're sitting there in the midst of a war, your country has had the surprise attack of Pearl Harbor, right? Thousands of Americans died. Saw the movie, it was a terrible movie, it was even worse, a tragedy. What do you do as a judge? It's not an easy question. I don't expect you to give me an answer. If you have one, I'd love it. But I don't have an answer.
Mm-hmm. But choosing it, what I'm trying to say is like by choosing not to, I don't know, by not at least giving him the opportunity and by not trying to apply his constitutional rights, it almost appears as if there is not a balance of power and the judicial branch is like cool with it.
Well, I think that's fair. I think what the court's basically saying is Congress sanctioned this, the president sanctioned it, the military sanctioned it, public opinion approves it. Mm-hmm. There's nothing left for us to do here.
Also, how much of it, and like we were talking about before, I mean, the court really has no enforcement mechanism.
Oh, you're exactly right. There's only the power of this judgment.
Even if they said no, I mean,
well,
and they already had their conflicts with Roosevelt to begin with.
Well, at this point, they were almost all Roosevelt appointees. But you're right. Let's move on to the second case now, Korematsu. I think that's actually good. David gave me a good segue to the second one. Korematsu, this will be in the next edition of the book, which you don't have yet. I'll give it to you this straight. Korematsu was decided on December 18th of 1944. Okay, December 18th, 1944. The day before that, the Western Command lifted the exclusion order. What? The day before Korematsu was decided, the Western Command lifted the exclusion order and allowed the Japanese Americans to return to their homes. Now, this wasn't made public until after the new year, January 2nd. But there is some evidence that Chief Justice Stone, who was in very close touch with the executive branch, delayed the release of Korematsu. He delayed the release of Korematsu. What do we make of that? Let me say this again, right? The dates aren't as important as the sequence here. The day after the government lifted the exclusion order, the Supreme Court issued its decision in Korematsu. Upholding the program that the government just rescinded. Now, in my humble opinion, the case was moot, right? Korematsu at that point was a free man. I mean, free, he could leave, right? But what makes the Korematsu decision even more jarring is they didn't need to reach that decision. They could just wait another week or two and said that this case is moot, dismiss it. They wanted to give the president this ruling, this power, knowing they would have no effect, right? They wanted to give the president this ruling, knowing it would have zero effect because the exclusion order was lifted, people could go home. But the decision to give President Roosevelt this ruling means that Korematsu can stay in the books now for decades. It is what Justice Robert Jackson, who's one of the greatest writers of the Supreme Court, I love his prose, he calls it like a loaded gun. Remember that line, right? It's a loaded gun just sitting there waiting to be fired. Because you never know how a Supreme Court precedent will be cited in the future. You never know. If I told you on, January 20th, 2001, that President Bush's administration would be defined by locking people up in Cuba from Afghanistan, I'm like, what the hell are you talking about, right? But the Guantanamo cases had to maybe raise some of the Korematsu issues, the same sorts of detention. Now, different issues, but the same scope of authority. So, it's unclear, right? It's unclear exactly why the court did what it did. But it was what, 6-3 vote. And during this time, over 100,000 people of Japanese heritage were held in these camps. Ironically, very few were held in Hawaii. It was mostly in the West Coast. And in case you're curious on the math, it's if you were 1/116th Japanese, you covered. So if you had a Japanese great-great-grandparent, you were covered. I think this was more strict than the Nazis. And I'm pretty sure it was at the same level of a restriction. And the Census Bureau provided help to see who had the Japanese ancestry.
So that's what I was going to ask.
Yeah, I knew you were going to ask that next. I got that in my notes, don't worry. I got you.
How,
The Census Bureau.
yeah.
The Census Bureau provided information of who had what ancestry.
So they went and found people.
If you didn't report, they would find you, yeah. I mean, that's what happened to Hirabayashi. He didn't show up and they arrested him. Right? I mean, he not only violated the curfew, but he also violated the exclusion order, and that's why they went after him. Right? The reason why the curfew in place was that if you were not at the exclusion order at the right time, they could just arrest you for violating the curfew. It was this, you're damned if you don't approach. All right, so let's do Korematsu. And again, the facts here are different, right? The facts here are different. This was not curfew. This was not keeping you detained at a camp. It was excluding you from the coast and these specific, we'll call the zones or territories, right? It was excluding you from these specific territories. Now, Korematsu was a U.S. citizen, right? I think he was born in the United States, I must be off, but I think he was definitely a U.S. citizen. And he was convicted of remaining in his home, right? So this is not even Korematsu, Hirabayashi, where he was arrested for going out at night. Korematsu was arrested for staying in his house, right? He was thrown in jail for staying in his house, not violating anyone. And he violated the order which directed that he report to this relocation center. There was no question about his loyalty to the United States. It didn't matter. So this goes to the court. Kevin, what happens? What does the court do here?
They upheld it.
They upheld it, right? On what grounds did they uphold it?
Pretty close to the same grounds as the first case. It wasn't because of his race. It was because they were at war with Japan.
Yeah. So the court basically says, it's true that, generally speaking, classifying people based on their race is a bad idea, right? But here it's appropriate. Why is it appropriate, Kevin?
Because during that time, Japan was at war with the U.S., and from my interpretation of it, they were scared.
Who's they? The justices?
They as the United States, or the
Yeah.
Supreme Court justices.
Yeah, I think that's right. So what the court says here is that racial classifications are subject to, quote, the most rigid scrutiny. the most rigid scrutiny. You'll study this later this term in what's called strict scrutiny. Strict scrutiny is the concept that what do you call it? Strict scrutiny is a concept that when the government wants to classify people based on race, they have to have a very good reason to do so. And Korematsu is one of the only cases ever decided by the court in which a racial classification is upheld. Generally, the court says when you have a racial classification, it's void. But here, quote, pressing public necessity may sometimes justify the existence of such restrictions, but mere racial antagonism cannot. So what do they mean by that? The government can't lock up Korematsu in a camp merely because they don't like him and they don't like Japanese people. But they can do it when there's a pressing public necessity. But this raises the question of the travel ban, which you mentioned before. What is the real reason? Is the real reason there's a legitimate threat from Japanese people in the United States? Or is this merely an excuse because they have a hatred towards Japanese people? Right. So the government says it's because of the war. We need national security. In order for the court to rule for Korematsu, they have to tell the government you're wrong. Now, I often pose this question to students, and it's not a fun question. I'll pose it again. You're writing the majority opinion here, right? What do you write? The government's racist, let him go. Okay. Then Korematsu, one of his associates, goes and blows up a bridge, or blows up a harbor. Then what's that do to the court? Right? Or flip side. You tell President Roosevelt to release Mr. Korematsu, and he says, no, I'm not going to do it. He's too dangerous. Make me. Are you going to be like Chief Justice Taney and saying that poor Marshall to the fort in Baltimore and ordering to arrest President Roosevelt? I want you to think about this. I'm not telling you what the answer is, but these are not easy questions. Rachel?
I mean, couldn't you make that same argument with someone who is born an American but is a convicted murderer, or someone who's a rapist, or...
But they get a trial, though.
Right.
The key point here is the government, the executive is locking up without any sort of hearing or any due process.
Mm-hmm.
And the executive says, look, we don't have time to give people hearings. We're too busy. We're prosecuting a war here, right? We can't establish tribunals to give them a hearing. And Elizabeth said, spies lie, right? Even if we give them a hearing and a loyalty oath, who's to know they won't lie to us? So the only way to keep the safety of the homeland on the coast is by putting them in Utah, in the desert, so they can grow sugar beets. Yeah. Yeah, Kevin.
The pressure that the Supreme Court was facing during this time, is that kind of similar to that of the Obama case? Because I believe you were saying that...
Obamacare.
Obamacare, sorry. Because I believe you were saying that they had some kind of pressure.
Yeah, I don't think it's anywhere even remotely close, but the idea is, like, I don't think there was any... If the Supreme Court had struck down Obamacare in 2012, I don't think President Obama said, too bad, we're going to enforce it anyway, right? So I think there's a different story, but the justices always have to be careful of the effect of their decisions and what impact they may have on the future. And I suspect here they thought Roosevelt would basically ignore us. And I mean, there's a data point here. There's a case that I don't assign, I think it's in your book, called Ex Parte Hearing. And this was a case involving Nazi saboteurs. It's actually a great story. So a bunch of Nazis took a submarine across the Atlantic, and they washed ashore on a beach, I think it was in Long Island, New York. And they took off their uniforms. They basically buried the uniforms in the sand. And some Coast Guard guy found them, and they kind of just ran away. I think that's what happened. And after a while, though, the Nazis started spending all their money, and they got in trouble. And so one of the Nazis said, I want to speak to J. Edgar Hoover, who's the head of the FBI. He says, I want to turn myself in and help the U.S. government. Roosevelt was not interested, so they set them up with a military tribunal. Even though they were in the United States, the courts were functioning, they put them through a military tribunal. As this tribunal was acting, they filed a challenge in the Supreme Court saying, hey, this tribunal is not a real judge. I need a real judge in the United States. Roosevelt had already made up his mind. These guys are going to be executed no matter what happened. And in fact, the Supreme Court issued a judgment, not a decision. They said, we rule in favor of Roosevelt. before the opinion was even issued, Roosevelt executed them, right? So even if the justices had changed their mind, they were already dead. In fact, they were buried in an unmarked field somewhere in D.C., so they would never be found. They were recently found. Apparently, a bunch of neo-Nazis go there to like hold ceremonies and stuff. So they're trying to keep the location secret. Yeah, the things I know. But this was a case where Roosevelt was going to execute these Nazi saboteurs, these Nazi spies. Didn't matter what the court was going to say. And I can't imagine the justices forgot that lesson. Right? So what we have here in Korematsu is saying, even though it's a racial classification, we're going to uphold it because of the public necessity of war. Right? It's not even that times of war the laws fall silent, it's that the law compels this result. We will defer to the government here. The court says we cannot reject the judgment of the military authorities that they're disloyal members of the population, and we can't say that the government lacks a good reason to isolate and deal with these people separately. Exclusion is deemed necessary because of an unascertained number of disloyal members of the group. The number was probably close to zero. Maybe it wasn't zero, but it was probably in the single digits. It was a very small number. Okay? The court acknowledges that there's a hardship imposed on American citizens. But hardship is part of the war. All citizens feel the impact of war. There are rations, there are curfews. But when our conditions of modern warfare are threatened by hostile forces, the power to protect must be commensurate with the threat and danger. Okay? So here, though critically, though, the court only discusses the exclusion. So any questions on the majority opinion in Korematsu? It's pretty breezy, right? If you read it, it's like no big deal, but it moves through pretty quick. Justice Jackson's dissent, I think, is important. What he says is this violates the due process rights of the people being detained. Jackson says the majority makes it seem like Korematsu violated a military order sanctioned by Congress, but it's not the case. He merely violated a military order that was never enacted by Congress. Okay. Justice Murphy's dissent is most famous for arguing that the Equal Protection Clause actually applies to the federal government. Now again, I read you it a few minutes ago. The 14th Amendment's Equal Protection Clause only applies to the states, not to the federal government. But Jackson says this is the ugly abyss of racism, and it violates equal protection. It's obvious racial discrimination. So about 10 years later, after Korematsu, the court would actually agree with Murphy. So in a case called Bolling v. Sharp, B-O-L-L-I-N-G versus Sharp, the Supreme Court considered, can the District of Columbia, which is federal, have a segregated school? They had ruled earlier that Kansas and other states could not segregate their schools. But the follow-up question is, what about a federal enclave, a federal city? And the court ruled that the District of Columbia could not. And they did this funky thing called reverse incorporation. And this is weird. No one actually thinks this is real, but this is what the court said. That the 14th Amendment, which was ratified in 1868, reverses and updates the 5th Amendment, ratified in 1791. So the 5th Amendment says you can't be deprived of liberty without due process of law. That means you can't be deprived of equal protection. There's not much more analysis than that. It's made up. But the bottom line is, under our current standard, the federal government and the state government are both subject to the Equal Protection Clause. And Justice Murphy alluded to that here. So once Murphy says the Equal Protection Clause applies to the feds, he says the government has not given any evidence. He says no reliable evidence. And that word reliable is actually very significant. Think about that for a minute. The government put forward evidence. What he's saying is it's not reliable evidence. He's making a judgment about the accuracy of military data. And pause on that for a minute, right? Pause on that for a minute. The judge is sitting in his chambers, maybe as a law clerk or two helping him out. Does he have intelligence briefings? Does he have classified reports? Does he know what's coming over the wire, what the code breakers have caught? He has no idea. So ask yourself with Justice Murphy, I know it's fun to read, right? But is he acting with hindsight bias, right? It's great to know today, right? It's great to know today that there were no spies, but how could they have known at the time? Yes.
When they're reviewing and making their rulings, they're not, especially on a case like this, they wouldn't have information to say, like they wouldn't have the intel information.
Do the judges have classified briefings?
That wouldn't be a part of a hearing?
Usually no. I mean, you have classified courts that, what's called the Foreign Intelligence Surveillance Court, the FISC, which approves warrants for classified information. But the Supreme Court has hearings in public. The briefs to the Supreme Court are public. And generally the government can't put in a brief to the public classified information.
But Congress has access to classified information. They don't, and their hearings are also public, but they're not.
Well, not all of them are public.
Right, but I mean, that's not.
They can have closed door hearings.
Right, so I just, like that, it doesn't make any sense to me that they wouldn't be reviewing classified information.
Well, actually, let me ask you the question differently. Let's say that classified information comes one way or the other, and it's not always clear what's going on, right? Let's say you have one report saying this problem exists, another report saying it doesn't. How do you reconcile that? Well, generally, a general would say, let's err on the side of safety. And the court says, no, I think that this other report, the minority report, is not true. Okay, then Gordon Hirabayashi blows up the Golden Gate Bridge. The other report was correct. So there's a judgment call, not just even seeing the evidence, but judging what weight to give to it. If you ever, anyone in military service here, you don't always know intelligence with any certainty. It's often chatter, right? You don't know what's going on, and you make your best guess. And for a judge to say, well, I don't think that chatter is strong enough. Okay? Not good answers, I know. But Murphy is going hard on the fact that there are no reliable evidence to justify this ban. It's misinformation, half-truths, and insinuation with racial animus behind it. And the military is not entitled to the great weight given to them. And I think someone mentioned earlier, Japanese and German, Italian and German citizens were given more process. They could have an oath of some sort. Okay. Why not hold loyalty hearings, right? Murphy says. I dissent, this is a famous passage. Racial discrimination in any form, in any degree, is no part whatever in our democratic way of life. It is unattractive in any setting, and it's utterly revolting when a free people who embrace the principles set forth in the Constitution. Justice Murphy was also the only Catholic in the court. Usually there was for a time there was a Catholic seat, right? There was one Catholic. And again, we don't think today about hatred towards Catholics, but it was a very prominent strand at the time. There was a fear that the Pope would basically, the same way that the Japanese people were loyal to the Emperor, that Catholics would be loyal to the Pope. And even when President Kennedy was elected in 1960, people thought he'd be an agent of the Pope. So this fear of loyalty, of dual allegiances, is not new. But I guess most Catholics and Japanese people have more or less assimilated to the point we don't worry about it. But the same sentiment applies to perhaps other groups. So any questions on Murphy? All right. Anyway, so the bottom line with Korematsu is that the majority was willing and able to defer to the military's determinations. The dissenters, to varying degrees, were hesitant to rely on their determinations, but ultimately said, we don't trust it, we don't think this evidence is reliable. But all of this came for naught, because the very day before, the government lifted the exclusion order. And there was no internet back then, right? You couldn't like publish an opinion with a PDF. So basically by the time anyone actually read the Korematsu opinion, at that point people were already starting to be released and being sent home. So it was a decision that didn't have much effect. And it's a decision that was based on no evidence. Not no reliable evidence, there was no evidence to support it. And it's generally agreed that it was done based on an irrational fear of Japanese Americans. Back in the 1980s, each survivor was given 20 grand as a reparation for being held in this camp, a total of $1.6 billion. And eventually, Korematsu's conviction was vacated. It was called a writ of coram nobis, C-O-R-A-M-N-O-B-I-S. This is this ancient writ, which courts can issue to nullify a conviction. Because, I mean, he was convicted, and the Supreme Court upheld his conviction. So, I mean, he was basically a felon, right, at that point. And the court nullified his conviction. Yes, Elizabeth?
So I was reading in one of the headnotes, I can't find it now, but it was saying like there's some acts, like when they were talking about the assimilation, they're like, oh, like it's true because it was what they were basing it on. There was some acts saying that like Japanese couldn't intermarry and all these things, and I was like, that's real? Like,
yes, so we'll study a case a couple weeks called Loving versus Virginia. So that case, anyone see the movie?
I studied it in family law, actually.
Oh, good. So there's a movie on it, which I'll show you a clip from in a few weeks. But for the 1960s, many states had laws that prohibited interracial marriage. What was called anti-miscegenation. Miscegenation means basically mixing of blood. And so it wasn't just black people couldn't marry white people, it's Asians couldn't marry whites, black people couldn't marry Asians. It was basically, you can only marry within your own race. And those laws were in effect in various states well into the 1960s. So the point, I think, which Elizabeth is raising is, if we can deny a Japanese person the right to marry who he wants, surely we can make him live in a camp for a couple months in time of war, right? Isn't it a much less intrusion into his freedom? Is that what you're getting at?
I guess, and two, it said in the 20s that they're in that same matter, maybe a different one, they couldn't own property, all these things. I don't know, it just seems so soon.
Well,
caught me by surprise, I don't know.
yeah, so we'll study the Equal Protection Clause later. Korematsu is a weird case because it's a war powers case, but it's also an equal protection case. It fits in this weird middle region. I never know where to teach it. I usually like doing it earlier rather than later because it's an important decision. But before the 1950s, the rule was one in Plessy v. Ferguson, which allowed separate treatment of races so long as it was deemed equal. And there were vast restrictions on ownership of property that were simply based on race. There's not any way to put it. Kevin?
So the video you showed us, they said they shut down their own markets and they moved into the camps. Would that affect commerce in any kind of way that you make an
Absolutely. Absolutely. Absolutely affects commerce. Are you asking if Congress regulate under its commerce powers?
argument?
I don't think they need to. They have the war powers, right? The Declaration of War activates new authority that didn't exist before.
So war powers go above commerce powers.
Yeah. Yeah, I don't think you even need a nexus to commerce at that point. You're literally having a local curfew statute.
But nobody's bothered to define what those excess war powers are. They just kind of deal with them as they come along.
Yeah, David. I mean, if you read Justice Jackson's opinion in Youngstown, and also his decision here, he basically says we don't have any clear guidance. But the fact that Congress blessed the president's action, I think the president and the court said, who are we to intervene?
Would this be any similarity with like the Patriot Act after 9/11 and how far-reaching that is as far as like what is the government has access to for us?
So the Patriot Act, I don't want to get too far into this, it's fairly confusing, but the summary is Congress gave the president sweeping authority to use search to find out terrorists and terrorist activity. And it was a statute that was not particularly well conceived because it was enacted in the rush after the worst terrorist attack in American history. And generally, when Congress acts in a very rash manner, it doesn't always read the bills that it passes. It's not until later that people are figuring out what the hell's going on. So that's not a good answer to your question, but it is. Yeah. Oh, you had it. So any other questions on Korematsu? Which,
So, were they, I know that they have reparations, the Japanese, but were they paid for their work in the internment camp?
I think that's what the reparations were for in part.
Oh.
I don't think they were being paid wages. And those videos I showed you, that was pretty glamorous. They were smiling and happy. I don't know how that works. I mean, it's
That's a whole nother issue
It
then.
just gets worse. and
Slavery?
worse.
Yeah.
yeah, I think there's a plausible 13th Amendment violation as well. That's the prohibition against slavery and involuntary servitude. There was no conviction to hold them in. There was a lot to study about this case.
Mm-hmm.
And again, the fact that they knew this order was being lifted, and they did it anyway, they didn't wait like another week or so until they, oh, this case is moot, that they actually sanctioned it, right? It's one thing to actually agree with the Roosevelt policy, but by writing this opinion, they sanctioned it and gave a precedent on the books that stayed in the books for some time. It's never actually been overruled, but it's not cited anymore.
Mm.
So with Korematsu, we have to ask ourselves, like, in the times of war, did the laws fall silent here? Any other questions on Korematsu? All right, Daniel, let's go on to Endo, last case. What were the, I have a picture of her somewhere. Couldn't find a picture for the case book. The problem is a lot of these pictures are not very high resolution, they don't reproduce well. Anyway, so Daniel, what are the facts in Endo, please? By the way, what does ex parte mean? Ex parte is basically, ex parte merriment, remember that last week? It's a habeas corpus action, right? You're basically seeking the release of a person who's held in captivity. So remember ex parte merriment, ex parte Milligan, ex parte Bowman, ex parte Endo. All right, Daniel, give me the facts here, please.
She was evacuated from Sacramento.
And again, evacuated is this very nice phrase. She was deported, right? She was removed.
It was to a relocation center.
Okay.
And she filed a petition to habeas corpus asking to be discharged
Good.
and restored to liberty. After she filed that, there was no decision made on that for quite some time.
Yeah.
But they relocated her to another center, which was in Utah.
Good.
Where she remained until, indefinitely.
Okay. So again, Hirabayashi challenged the curfew. Korematsu challenged the exclusion. And Endo, the third case in the trilogy, challenges the detention at these various camps. And the justices broke these apart very deliberately. They handled them in separate pieces. Okay? So what happened was that they challenged her they challenged her detention in these camps. Now the Supreme Court's decision here is very strange. Everyone notice that? They didn't come out and say it's unconstitutional. They ultimately ruled for her, but they didn't actually address the constitutional question of whether she can be detained without any sort of hearing. China, what did the court actually do here? It's a very strange holding.
I believe I don't really understand how they ruled in her favor.
Yeah, it's weird, right? Everyone
Yeah.
else. Well, walk me through as far as you understand. Maybe I'll call on one of your colleagues to finish it up. Let's just start me off. Like, what did they start? What's like their premise?
They obviously they didn't address the constitutional issue, but it was more about her loyalty and how they were deciding whether or not she would be loyal to the United States. And
Well, let me ask you this question.
mhm.
Which branch of government created the detention order? Which element in our government created the detention order?
The military?
Was it enacted by Congress?
I believe so.
No, did the Congress actually create the detention
No.
order? Okay. That's the key of this entire case. What the court says is there's no act of Congress and there's no executive order of the president that approves this detention. That the detention is being authorized by General DeWitt, by his orders. And this is the key move, right? All we have is a general. We don't have anything from Congress. Congress is presumed to act lawfully. This order, they say, is not what Congress intended. Follow me here, right? What they're basically saying is that the general went too far. That the general went beyond what Congress had authorized, and therefore we're going to invalidate the general's order. But we're not saying it's unconstitutional. We're simply saying this is not what Congress had in mind. What a bizarre holding, Kelly, right? Isn't that a strange holding? Did Congress and the President not have in mind to lock up Japanese people in camps for all these years? Can you plausibly argue that? No, why not?
I mean, they don't have the right to detain.
Do you think Congress was aware that 100,000 people being locked up in desert camps?
They were aware?
Yeah.
Well, I mean, they had to have been aware.
Watch the movie just the same as I did, right? Do you think when Congress passed these statutes after Pearl Harbor, they knew that Roosevelt wanted to lock people up?
Mm-hmm.
I do. It's just not a secret.
He said his wife.
It's not a secret. He sent his wife there. So what the court basically says here is this. Congress would have never enacted this sort of statute. The statute Congress enacted does not permit this sort of broad application. Therefore, the person screwed up here is not Congress, but the general. Bad general, bad, right? So as a result, the court said, we will not allow the enforcement of this military order, which again had already been rescinded at this point. But they were able to avoid ruling that was unconstitutional. Now, Rachel, let me ask you a follow-up question. What if Congress had enacted a statute, not General DeWitt, but Congress enacted a statute that said, we will lock you up if you're Japanese, period, right? The exact, I showed you the poster before, right? So this poster, right? So instead of it coming from Western Command, it came from U.S. Congress, signed by the President. Would that statute then be constitutional under this ruling?
No, because they cannot enact legislation that would be discriminatory.
What did Korematsu just hold 5 minutes ago? Korematsu and Endo decided the same day. They were issued back to back.
Under Korematsu, they would say that it would be constitutional. You can discriminate.
Well, discriminate to exclude or discriminate to detain?
Oh.
Oh.
Well,
See, that's the rub, right?
yeah, and they never mentioned detention in that 1942 Act. It was never mentioned.
And that's why my question is, what if Congress had created the Detention Act in 1942? Didn't come from the general, didn't come from the Western Command, it came from the Congress. In other words, Rachel, does Endo hold that Congress lacks the power to detain? Is that the holding of Endo?
I'm really not sure. I feel like it is. They are saying that, but also I think that they're saying more of that DeWitt doesn't have the power to detain.
They're definitely saying DeWitt lacks the power, but if Congress gave him that power, Congress said explicitly. Congress enacted this poster by statute.
Mm-hmm.
I don't know. Kevin, you're shaking your head. What do you think?
From my understanding of it, Endo is mainly off of the general, not Congress and the president.
I think they left the door open, didn't they? I think, my reading, maybe you'll disagree, but I think my reading of Endo is the court left open the door if Congress wanted to enact the detention statute. Maybe yes, maybe no, I don't know, maybe I'm wrong. But they avoid the constitutional question, right? They don't say that the military can do this, but they say maybe Congress can. They're not really saying. So again, even though this was a defeat for the government, at that point the order had already been lifted, and they did not disable Congress from doing the same later. Yeah. By 1944, the war was already winding down, right? People knew that at some point soon, the war would probably be over next year or two. So they weren't maybe too worried, but they didn't want to give a ruling to that this was unconstitutional. So even though Endo was the only one of the three that the government lost, they lost on a very narrow technical ground. They didn't really lose the core argument that the Congress and the President, when united, could detain people on the basis of their race. So what happened after this? They were decided, Endo and Korematsu, on December 18th. By January 2nd, or after New Year's Day, the exclusion order was officially lifted. The internees sounds wrong, internees I guess, were given $25 and a train ticket back home. And the last camp stayed open until 1946. So I guess not everyone got the memo right away. And eventually, Endo was released. You have the concurring opinions of Murphy and Roberts, who basically said, let's not fool ourselves, this is unconstitutional. And actually, I think earlier I said Justice Jackson, I meant, and that was actually from Justice Roberts' opinion, so I apologize for confusing those. But I think I got them all. Should not confuse Jackson and Roberts, not even close. All right, and so any questions on the detention cases? And again, these are the sorts of cases that it's easy to say, oh yeah, we can say these, whatever, no big deal, but nothing stops these cases from recurring. I don't think the child line cases are even in the same ballpark as these, but the court may so find. Any other questions in the Japanese detention cases? I love a class of 10 people. I wish I could do this, but unfortunately it's not economical for the school. All right, let's do the last case. Or actually, well, not the last, let's do the first case, Dames and Moore versus Regan. And again, it's not Reagan. This is not President Reagan. That's what you said?
I said it was pronounced Regan. And
yeah, it's pronounced Regan. And it involves Secretary of the Treasury, I think it's Don Regan. Yeah, Donald Regan. So it's not President Reagan. So this case arose following the Iranian hostage crisis, which was something that I didn't live through. I don't think anyone in this room lived through, so I guess we can't talk about it. But in 1979, the American embassy in Tehran was seized, and the people inside were taken hostage. Did anyone see the movie Argo? I didn't like the movie. The book was really good. The movie, Ben Affleck, not a fan. But the hostages were held there until January 20th, 1981 now. The date, January 20th, has any meaning, right? If the date January 20th has any meaning, it's the inauguration day. And basically the same day that President Reagan was inaugurated, the hostages were released. But that doesn't mean it was all Reagan. There was a lot of preparation work put by Carter before. But one of the conditions of the release of the hostages was that the government of the United States and the governments of Iran agreed to settle all claims, right? In other words, they just wanted to wipe the slate clean. So what if you were a company that had a lawsuit pending against Iran? What the Reagan administration said, actually this is the Reagan administration headed by Regan, it's confusing, but the Reagan administration said was, we're going to suspend your claims, right? Any pending lawsuits or any judgments pending against Iranian government firms, we're going to simply suspend it. And we'll transfer it to a tribunal, which is this, it's not really a court, but it operates like a court to decide who gets what money. So they took all this money that was pending and they said, okay, divide it up. And as part of the treaty, the U.S. was obligated to terminate all legal proceedings. Okay? Now, the Dames and Moore Company, is there a logo? the Dames and Moore Company had a judgment against the Iranian Atomic Energy Organization. And they claimed a breach of contract that they helped to develop a nuclear power plant in Iran. This is a run-of-the-mill breach of contract case, right? And they actually had a judgment of about $3 million. And they sought to attach Iranian assets to the United States. But after President Reagan's executive order, Dames and Moore challenged the executive order itself. They said that the executive order deprives them of their judgment. And they said the president lacks the statutory authority to take these actions. Okay? So this case is not about Dames and Moore versus Iran. This case is about Dames and Moore versus the Reagan administration, saying that the executive branch lacked the power to suspend the claims which are pending in court. Everyone get the facts. Facts are a little bit tricky, so I like to summarize them. So the decision itself was written in only 8 days. I talked to some sources. Apparently, Justice Rehnquist wrote this over the weekend in his cabin somewhere up northeast. And one of the more remarkable parts about this is that, as I mentioned, Justice Rehnquist clerked for Justice Jackson the year Youngstown was decided. And who was Justice Rehnquist's clerk that term? That guy, John Roberts. The current Chief Justice clerk for Rehnquist the year Youngstown was decided. And Rehnquist decided for Jackson the year Youngstown was decided. So you have these two foundational separation of powers cases that were decided with either Rehnquist or Roberts at the helm. Actually, Rehnquist was at the helm of both of them. Okay. So the question becomes this with Dames and Moore: where did the court get the authority from to take these actions? Right. Ashley, you're next. Where did the court find that the executive branch had the authority to seize and to suspend these claims? Where did they get this authority from?
So, it wasn't from the IEEPA.
So what's IEPA as it's pronounced? What's IEPA? One of my favorite acronyms.
International Emergency Economic Powers Act.
Okay. Did IEPA give the president the power to suspend claims?
Yes, or to terminate. Yeah.
Well, what did IEPA actually allow the president to do?
So to terminate litigation between the governments and to bring.
Well, let me help you. So IEPA authorized the nullification of attachments, right? What does that mean? Let's say you have a judgment against Iran, and Iran doesn't pay, and Iran has a bank account in the United States. You can then attach that bank account to try and get money from it. What IEPA says is you can nullify the attachments, but IEPA does not authorize the president to suspend the claims in American courts, right? The statute does not do this. So we start from the premise that the president can get power from two places, right? From a statute or from Congress. It's not argued that the statute or the Constitution, two places, the statute or Constitution. It's not argued that the Constitution gives the president this power, so he needs to look to a statute. So IEPA doesn't do it directly. David, what about the Hostage Act? We talked about that. Does the Hostage Act give the president this power directly?
No, not directly.
No. So why does the president lose here, right? Why is that not the end of the case?
Because I think they basically said that those acts kind of set the groundwork, because then, you know, using Jackson's opinion from Youngstown,
Good.
they said that the legislation like invites a measure of independent authority from the president.
Okay, very good. So we go back to Youngstown, right? And what the court basically says here is, Justice Black's majority opinion is nice, but we're going to go with Youngstown and Jackson concurring opinion, right? The court more or less adopts Jackson's concurring opinion, but I don't think they do so faithfully. And to give you the history again, Justice Rehnquist did not agree with Youngstown. He thought it was wrong. So the first zone of Youngstown, right, is when the President acts pursuant to an express or implied authorization from Congress. He exercises his own powers plus the powers of Congress. David, what zone does Justice Rehnquist think we're in here?
He doesn't really think we're in any of the three zones. He kind of said it kind of falls more on a spectrum of, you know.
Oh, I think he thinks we're in a zone here. I think Rehnquist thinks we're in a zone. We're not in twilight here. We're not in the second zone. And we're definitely not in the third.
Then I'll go with zone 3.
No. What's zone 3?
Zone 3 is where, I thought zone 3 was where Congress
Says
approved.
no.
Oh, zone 3.
Zone 1 is where Congress says yes. Zone 2 is where Congress says meh. And zone 3 is where Congress says no. So where does Rehnquist find us here?
Zone 1.
Rehnquist thinks we're in zone 1. And this is the key sentence in the entire opinion. It says that both statutes, both IEPA and the Hostage Act, are, quote, highly relevant in the looser sense of indicating congressional acceptance of a broad scope for executive action. That even though the statutes don't expressly give the president this power, they're relevant in the looser sense of indicating Congress is okay with the president taking these actions. Now, I don't think that's a faithful application of Youngstown in the least. Congress considered whether the president should have the power to suspend claims and withheld it. In my mind, that's identical to Youngstown, where Congress considered giving the president the power to seize steel mills, and they withheld it. So I often see James and Moore as almost like a tweaking of Youngstown and not a faithful application. And that's fine, but Rehnquist says Congress can't anticipate every possible action the president may take. So they give general delegations, and that puts us into the first tier. It indicates a congressional willingness that the president have broad discretion over affairs concerning foreign sovereigns. And there's nothing in the legislative history to dispute that. But I think this is definitely the first tier of Youngstown. Okay. Another point that Rehnquist raises is, Elizabeth, after Reagan seized or suspended the litigation, did Congress object in any way? No, they didn't. What'd they do?
They haven't, I don't think they did anything.
Yeah, they did nothing. And in fact, they actually, some members of Congress said, we approve of this. So Rehnquist sees this as an acquiescence. What does acquiescence mean? Basically, Congress gives us, yeah, we agree with this. This is a good idea. There was no objection. So here, Rehnquist reads the statutes in a very loose fashion and says because Congress didn't object, they basically have implicitly approved it. They're going along with it. Right? So this to summarize the case, based on the general character of legislation, you have IEPA, you have the Hostage Act, and Congress has acquiesced to these sorts of executive claim settlements. The president is authorized to act. Again, this was not a time of war, but had the court told the president, no, you can't seize these bank accounts, what would have been the consequence? The treaty with Iran would have been scuttled. Right? The hostage is released on the promise of the U.S. government to suspend these claims. What would then happen if the court told the government, you can't suspend these claims? And the hostages don't go back, but maybe there'll be more war, more fighting in the Middle East. So again, you have to look at this in the context of what was decided. Had the court ruled against the executive branch here, what would that have done to our foreign policy? But that's McCullough again, right? If we just read the Constitution to endure for the ages, then what is it? Not easy questions. In the very last paragraph, the court says, we emphasize the narrowness of our decision. Kevin, what is that? We emphasize the narrowness of our decision. What's Rehnquist getting at there?
It just applies to this.
Yeah. Why is he writing that? What's that basically signaling to the world?
That it's just gonna happen for this one time. It doesn't mean if you do this to us again, we're gonna do the same thing.
But does anyone actually believe that?
Probably not.
Yeah.
Not like Rocket Man right now.
Was that?
Not like Rocket Man.
Yeah, like Rocket Man, exactly. The court here is saying, look, we're not making any ruling, we're not setting a precedent, it's only for this case. Bullshit, right? If you read Bush v. Gore, which was a decision concerning the 2000 election, there's a similar passage that says, we are only deciding the dispute before us, I'm paraphrasing, right? We're only deciding this dispute. This should not be decided anywhere else. When you're in the Supreme Court and you publish a decision, you can't tell people not to cite it. That's not how this works. People have cited Dames and Moore in other cases. People have cited Bush v. Gore in other cases. Right? You create this precedent, it's a precedent on the books.
So why even publish an opinion on it?
Make themselves feel better. Say, look, we told you not to apply this case, but you wrote it, right?
So people actually use it in arguments, like, as binding authority?
It's a Supreme Court decision, 9-0, unanimous.
I mean, if you were taking this in front of a judge for whatever reason, and you brought this case up, I don't understand how you could not expect the other side to just, like, tear you apart on that one.
It's precedent. No one remembers that part. Most law students don't even read that far, but I make sure it's in the book. Any questions on Dames and Moore? Very important case. Probably one of the most important separation of power cases in the last 30 years. 35 years at this point. All right, let's do briefly the Ziglar v. Abbasi case. So the supplement should be available. If you want to buy it online, buy it online. I really don't care where you get it. But it should be in the bookstore also by next week. Like, I gave you the PDF of the opinion. Okay? Daniel, do these facts seem familiar from a case you did in CivPro?
CivPro?
Yeah. Do these facts of the Ziglar case seem familiar?
Probably.
What cases remind you of? Oh, they probably didn't put it in your book.
Iqbal?
Iqbal! Yeah, what was Iqbal about? You remember?
Oh, no.
On purpose.
Maybe slightly.
Well, the problem with Iqbal is it's a CivPro case, but it's really a civil rights case, right?
Mm-hmm.
It's a civil rights case.
Yeah.
In the wake of 9/11, right? In the wake of 9/11, thousands of men were rounded up throughout the country. Actually, hundreds, not thousands, I'm sorry, I'll give you the right number. Hundreds of men were rounded up throughout the country on suspicion that they were involved in the 9/11 attacks. And they were almost all Muslim men, just to be frank here, right? And they were held in captivity for days, weeks, and maybe months. Many of these people were beaten, right? Not treated in good conditions, put in deplorable conditions. Iqbal was a lawsuit against, who's Ashcroft? He was the Attorney General. And right? Iqbal was the guy detained, and Ashcroft was the AG. And they sued the Attorney General for basically violation of their rights. And the reason why Iqbal was dismissed was they did not assert with plausibility that he knew about their rights being violated. That was the entire case, right? All you care about is plausible. It's the only word you would care about from that case. But it was a question about whether the government could be held liable for their rights. So Ziglar, almost, 2017, Iqbal was 2008 or 9? So basically 8 years later, the case came back up with a different plaintiff, Ziglar and Abbasi. And they asserted similar claims, right? could the government be held liable for the detention? Now, this was a unique case, and the vote was 4-3. How was it 4-3? Justice Kagan recused because she was a Solicitor General. Justice Sotomayor recused because she was on the Second Circuit Court of Appeals when this case came up. And at the time, Justice Scalia had not been replaced yet. So you're down to 7 justices, right? Was it 6? No, it was 4-2. I'm sorry. I can't even count. Yeah, I lost count. It was a 4-2 vote, which is very strange. What the heck is a 4-2 decision? I don't even know. It's unclear what the value of a 4-justice block is. It's a question which people like to argue about. But the reason why I put this in here is to give you the contrast between Kennedy and Breyer, right? And Kennedy says, national security is a prerogative of the central government. And when courts inquire into this, they have to be hesitant. Right? But then you have Breyer in his dissent. And he quotes that line that in times of war, the laws fall silent. And the courts must stand ready to intervene. Right? And as he cites the Guantanamo cases. But what's important about this case, is that it's not really decided in a time of war. Right? This is not decided when, planes are flying over Japan, or when the Korean War is raging, or even when the Iranian hostage crisis has just been simmered. This was decided in 2017, 15 years after 9/11, and his suit for damages. Mr. Abbasi was already set free. He's been out for a while. There's no indication he's dangerous. But even in a case for damages a decade later, you still see the hesitancy of the court to extend causes of action for these sorts of cases. Now, I don't want you to get bogged down in Bivens, which is this made-up doctrine that you can sue the government. It's not real. The courts think it is, but here what the court's saying is you can't sue. But the debate between Breyer and Kennedy here is not much different than the debate between Murphy and Black in Korematsu. It's the same old theme of how are courts supposed to intercede when the government says that the security of the people commands it. Okay. Somewhat short in time. I don't know how much further I should go into the case with this only 2 minutes left. Questions on Ziglar, Abbasi. I like putting this at the end of the unit. It'll be the final chapter in the unit next semester, next book, because it brings these themes together that even when there's no meaningful war going on, there is a war, but not affecting this case, the courts still have this hesitancy. Anything on Korematsu and Abbasi, the games of war? All right, so to summarize, the lesson here today is not necessarily to say that any one decision is right or wrong, but it's to question what are the institutional strengths of each branch of government. The executive branch can respond quickly to threats of danger. Congress can respond a little bit slower because they're basically working on whatever the executive branch tells them. They can pass statutes, and by passing statutes, they give more authority to the president. But then you have the courts, these charming lawyers sitting in their chambers with mahogany wood, with their law clerks running around, these smartest kids in America, and they don't get classified briefings. They don't get intelligence. And sometimes they think that the evidence the government gives them is not reliable. I didn't cover the Guantanamo cases, but you can read up on them. That's one of those cases. But these issues do not disappear, and they continue to arise over and over again. And indeed, about 3.5 weeks from today, the court will consider the travel ban. I will be there for the arguments. I don't know what they're going to do. Reporters keep asking, what's going to happen? I don't know. I stopped making predictions. I think the government wins, but not putting money on it. Anything? I will see you all on Sunday in this room, and we will be covering was it class 11? Class 11, which is the separation of powers. The appointment and removal powers, one of my favorite topics. Okay, thank you so much.